attention.
This is my second slip and fall summary disposition motion this week.
Yeah, we had Taco Bell Monday.
Yeah. Okay. We are streaming. Let me let these folks in. Okay, waiting for one last audio connection and we'll get started.
Is that me, Judge?
Hello.
Is that me?
No, yours is connected. It was
Okay.
Mr. Kaczynski that I was waiting on.
Okay. Hi, Brian.
How you doing, Rick?
Good. How are you?
Good afternoon, Judge.
Afternoon.
Okay.
Judge, how's the hip?
Wow, it's amazing. I actually was back on the basketball court until they shut the Y back down again. But anyway, yeah, hip's doing great. Although my other hip, which is just as bad according to the X-rays, but it never really gave me many problems, is giving me problems now.
Can you jump any higher?
No.
Me neither.
If there's any air at all between the floor and the sole of my foot, it's a miracle.
The Bill Lambier story.
Okay, so we are live streaming. In case you can't tell, I am not at the courthouse. We had a positive COVID case, and anybody that had contact with that case or contact with someone else who had contact with that case had to go home. So here I am. And I've been doing court from home. The internet's not the best, but generally it's been working. The only record I'm able to make is the YouTube live stream that if it's ever needed for appeal purposes will be available. But because we're not in the courtroom, we're not putting anything on the official court record. So anyway, with that, Keene versus Chu. Excellent name for a fast food franchise. Counsel, if you could each state your appearances, please, for the record.
Brian Kaczynski, Your Honor, for the plaintiff.
Rick Juridat on behalf of defendant Chu, operating as Arby's, Your Honor.
Okay, so this is actually my second Chu case. They sued the people that were building. Well, let me just take that back. They sued their landlord because of construction that was taking place next. So I even recognized the name when it showed up on my docket again. So with that, Mr. Juridat, I have read your motion and brief. Mr. Kaczynski, I have read your response, but is there anything else I need to know about this case? Go ahead, Mr. Juridat, this is your motion.
Thanks, Judge. Did you have an opportunity to review my reply brief by chance?
There's nobody at the clerk's office.
I know.
Skeleton crew, and they're only doing whatever they can do. So anything that came in with it wouldn't have been scanned. It might not even have been marked as received. So no, I did not. I read everything I had access to.
Judge, I tried to drop off a photograph today. I thought it was attached to our brief, and it was not. It would give you an idea of the inside of the restaurant where the incident occurred, along with where the water was in relationship to the table. And I thought
I did have a photograph. I can't remember whose brief it was attached to that showed. You're welcome to share the screen and put it up there just to make sure we're looking at the same picture. Do you have it on your computer?
I do, Judge, and I'm gonna try to do this here. I was just taught about 4 minutes ago how to do it. So
Oh, good. Well, this should be interesting then.
okay, I'm looking for a share screen.
It's
Okay.
right at the bottom, green.
Okay.
Well,
Can anybody see that?
I can.
Great.
I see two pictures.
Good. Judge, you could disregard the one on the right, but the photograph on the left that has the markings on it, on that day, that is February 14th of 2019, the plaintiff and Mr. Zabrowski entered the Arby's restaurant and went to the front counter and ordered their food. After the order was placed, Timothy Keene, the plaintiff, walked as depicted in the photograph. That is from the front counter towards the table that's shown. And he sat down in the chair that has the X on it. After the food was given to Mr. Zabrowski, he walked the opposite way. It's kind of an island there, if you will. And he came from the opposite direction and obviously sat at the same table. What's depicted in the black ink in the long, somewhat curved area is what Mr. Zabrowski claims to be the area where the water was when he first observed it.
Right, say that again, Rick, because I lost.
Sure. The black heavy line that's drawn for the an extended period there, that's where Mr. Zabrowski claims the water was situated. Okay. And so it would appear that Mr. Keene would have either walked through or around the water that counsel believes that he stepped in on the way to his table, or it somehow appeared after they were sitting there and eating for 10 minutes or whatever took them to eat, before they stood up to go. So, but what's important here, Judge, is that we don't have any dispute here that the plaintiff is unable to testify. And there's also no dispute that there's only one eyewitness, and that's his de facto stepfather, Mr. Zabrowski. That being the case, Judge, we think there's 3 reasons why summary disposition should be granted. And if I can, Judge, I'd like to do them one at a time so we don't confuse the issues. Is that okay?
That would me.
Okay. Well, the first is we think we're entitled to summary disposition because the plaintiff cannot establish how or why he fell. And we know that's true, Judge, because counsel refers to 3 witnesses: Ms. Locke, who was an employee of Arby's, Ms. Maxwell, who was an employee of Arby's, and Mr. Zabrowski, of course. However, Judge, Ms. Locke testified in no uncertain terms that she did not observe Mr. Keene fall. She responded after she heard some commotion, but she didn't actually see him fall. And that's at page 10 of her deposition. Likewise.
Well, let me ask you, while we're talking about her, does she acknowledge seeing water on this area of the floor that he was lying in?
Not Ms. Locke, Judge, no. It's the other employee.
So did she see him at any point while he was lying on the floor or after he was helped up?
Yes, she did. She did.
Okay,
Judge.
So she was in this immediate area.
She was behind the counter, and she testified that she heard some commotion and she looked over.
I got you. She didn't come out from behind the counter and walk up to the area?
I think she did, Judge. I think she did. She did.
Was she asked if she saw anything on the floor?
She was, and she couldn't recall seeing any water anywhere.
Okay, thank you. Go ahead.
Now, Ms. Maxwell, the other employee, also testified that she did not observe the fall itself. She was notified by someone else in the restaurant that someone had fallen. Now, when she got out there, which was a little bit after Ms. Locke, she testified that she did see some damp spots or some wetness in the area where the young man had fallen. So, Judge,
Did she have any knowledge as to how that wetness got there?
none, Your Honor, none.
I
don't want to say none, Judge, because she testified that it was a wet day and they had the cones out and they were mopping periodically as they would. I mean, she assumed or speculated that it could have been water tracked in from outside. She had no idea how specifically that it could have gotten there.
So,
Well, that's not true. May I respond? Because that's not true. I mean, she testified on page 27 that it had been recently mopped. I mean, that's what defendant continues to ignore. There's testimony that had been recently mopped from 2 witnesses. So yes, she does know how the water got there.
Well, Judge,
was she the one that did the mopping?
no.
No, another employee did. Another employee did.
Okay.
But there's testimony from 2 employees that had been recently mopped just before my client's fall.
Here, Judge, this is why I don't want to, we're going to confuse 3 specific issues here. I'm going to go back to how and why the plaintiff fell. So counsel relies upon Ms. Locke, who admitted she didn't see the fall, Ms. Maxwell, who didn't see the fall, and Mr. Zabrowski, who claims he saw the fall. So now we're left with essentially the only eyewitness, that's Mr. Zabrowski, who claims that he saw the fall. Now, Judge,
Well, wait a minute. When you say claims he saw, I get it. You don't want to.
well, he fell.
The reality is he was sitting at the opposite side of this table and son fall. That's what I thought I heard.
Well, what happens is they both get up to leave after they eat, and they're heading towards the opposite direction that Timothy came to begin with, and they're following fairly close to one another. And Mr. Zabrowski testified that he saw Mr. Keene fall.
Thank you for clarifying. I was under the impression that they were still at the table when that happened. They had already started to walk away from the table.
Yes, Judge, the red.
And help me understand when you say opposite direction. As I look at this photograph, the at least one entrance to this restaurant is just around the corner from the waste receptacles, just to the right of that. Am I right?
Yes, Your Honor.
And the picture on the other side is in fact that same waste receptacle and the door that's immediately behind it.
It is.
So when they came in the restaurant, did they come in through that door?
I believe they did, Your Honor, but I'm not certain if they came in that door or the one on the opposite side. I'm not certain.
But whichever door they came in, when they walked out, they walked in the into the chair that Timothy Keene was sitting in is facing.
Judge, it kind of cut out there a little bit. Could you repeat that, please?
Yeah, I'm just trying to verify when you say they walked out in the opposite direction. That didn't tell me much because I didn't know how they came in.
Sure. I meant the opposite direction that Timothy entered the dining room. Timothy entered the dining room. That's actually an arrow on that photograph, and that's the direction Timothy took to sit down.
Okay.
And when they left, they were leaving by that same path, just the opposite way.
Oh, okay.
And the 3 exits,
which would suggest they're probably headed to that exit.
Presumably. And Judge, the 3 X's that you see there, that would have been where Mr. Zabrowski believes Timothy ended up on the ground after he got up to leave.
No, it's the black. That's the way he walked. The 3 exits are where he walked, Rick. That's where he said he was walking. I don't think that's where he said he landed. He said he landed in the lobby. All right, I won't say anything.
Okay, well, it's either way, Judge. It's right there.
If the black squiggly line is the water as described by stepdad. And stepdad said he saw Timothy puddle of water. It would suggest that that must have been where he was lying.
Yes, I believe so. I believe that's true, Judge. Yes. Whether it's a little to the right, a little to the left, I'm not sure as I'm sitting here today. I don't know for sure. But anyway, Judge, the point of this all is there's only one eyewitness to this, and it's Mr. Zabrowski. And I'm trying to find out from him what happened to Timothy, whether he tripped, whether he had a seizure, whether he fell, whatever the case may be. I'm trying to find out how he ended up on the ground and was injured. And I asked him specifically, and this is at page 36, you watched him fall, is that correct? Answer, yes. Question, but you're not looking at his feet though, true? Answer, I'm just looking at him. Question, right, because he's right, he's in front of you. You're not looking at his feet. Answer, right. And then he goes on, Judge, because I'm trying to give him an opportunity to tell me what he saw. And this is how it goes. Okay, did you actually see a foot slip? Answer, I seen his whole body go down. Question, right. That's not my question. Did you actually see his foot slip? Answer, questions like this, I'm not going to answer. Question, because you're not looking at his feet. Answer, no, because it's intimidating what you're doing. Question, so you're refusing to answer. Answer, that's right. So the only eyewitness, Judge, can't testify as to how Mr. Keene ended up on the floor. In response to any motion for summary disposition, Judge, it's plaintiff's obligation to come forward with evidence and not mere speculation as to how this fall occurred. Judge, I think here's how I think this works. I don't think it's possible for a witness to refuse to answer and that somehow creates an issue of fact when it's plaintiff's obligation to come forward with that information. And quite frankly, he's had conversations with counsel before this. I mean, he's not his client, but we all know how that works. Counsel's at the deposition. He could have asked Mr. Zabrowski, hey, did you see a foot slip? How do you know he slipped as opposed to tripping? Judge, the law is clear. It's in our brief. If one possible cause is not more likely than the others, then all it amounts to is pure speculation and conjecture, and we're entitled to summary disposition on that issue alone. And I'll let counsel respond. Thank you.
Well, wait, before you do, obviously one possible cause that he slipped in the water that was on the floor. What are the other possible causes? He just collapsed?
He could do that. He could trip on the chair. He could trip on his own feet. He could have a seizure. There could be any number of possibilities, Judge. And Judge, the idea is once again, it's plaintiff's obligation to show more likely than not that one of these, I would assume slipping here, is more likely than the rest. And if you don't have a witness that said he slipped, I don't know how you have a case.
Your Honor, if I may respond.
You may, sir.
Okay, thank you, Your Honor. I don't think Rick is really being fair with the facts. My client was frustrated at that point because Rick kept on asking the same question over and over. What Rick didn't read to you when he was reading the testimony, I'd like to read to you now. Question, this is on page 36, but if you're not looking at his feet, how do you know that he didn't trip as opposed to slipping? Answer, and this is what Rick didn't answer. He didn't trip, he fell. The water was there. He hit the water and he went down. Then Rick says, but once again, you weren't looking at his feet. True. Answer, I was looking at him. I'm looking at you. I'm looking at his whole body. He testified a number of times. Rick kept on asking him over and over until Mr. Zabrowski became frustrated. There's clear evidence that there is a logic. This is not conjecture. This is not speculation. There's a logical inference. And in Michigan, the law is very clear that where there is a logical inference, this is a question of fact for the jury. What do we know? We know the floor had been freshly mopped. We know it had been mopped by defendant's employees shortly after my client arrived. We know that there was some water on the floor that wasn't all that visible because their own employees didn't see it. We know that this man went down. Now, Rick, he says in his brief that because my client can't testify, that it's all speculation, and that's not the law. Mr. Zabrowski saw my client go down. He then saw that there was water there. Indeed, defendant's own employee, Amy Locke, testified to the same thing, that she also said it. She didn't see him fall, but then when she went over there, it appeared that he had slipped. There's no other reason. His shoes were not untied. That's established in the record. There's nothing for him to trip on. There's a freshly mopped floor with no signs, and that's the evidence that there were no signs in that area, and he went down. And Mr. Zabrowski saw his body go down. So we have an inference. Now, Rick can argue that to the jury, that how do we know he didn't trip? But I've met my burden here, Your Honor. This is not the realm of conjecture because Mr. Zabrowski saw him go down on this water and stated very clearly he didn't trip. He fell. Does it matter that he wasn't watching his feet? Rick can argue, Mr. Godot can argue that to the jury, but we are able to get to the jury on this issue because we have created a sequence of events that point to the logical inference. What other reason would it be for him to fall? There's no other reason besides the freshly mopped floor. And you can see this floor with its tile floor. It's obviously very slippery when it's wet. He went down. We've met our burden, Your Honor. We've taken this out of the realm of conjecture with Mr. Zabrowski's testimony, as well as the statement from their employee, Amy Locke, who said that it looked like that he had slipped. In fact, Amy Locke testified on page 15, did it appear that the gentleman had slipped? And she answered yes. And a question, why do you say that? Because the floor was wet. There's a logical sequence of events here, Your Honor. This case should not be dismissed because of conjecture. And I've attached cases very similar to this one. This is a question of fact for the jury.
Judge, may I respond?
Yes.
Judge, nothing could be further from the truth or the law. The idea is this: if someone falls in an icy parking lot, that alone does not create a jury question as to how or why that particular person fell. Once again, counsel seems to indicate or believe that there's only one possible logical inference if somebody falls. That is, if you're on ice or a slippery substance, well, then you must have slipped. Well, that's not the case, Judge. And the cases that we've cited, I've cited several where people claim to have fallen on steps that were crooked and some other cases like that. And the Court of Appeals and the Michigan Supreme Court have been consistent in their holdings that no, here's what you need. You need direct evidence that rules out other causes. Look at, he could have fallen. He could have tripped over his own feet. He could have stopped short. His foot could have stopped suddenly. Any number of reasons why people fall. To say that just because there's water on the floor and somebody fell, the logical inferences, the jury inferences is that you slipped. That's not the law, Judge. It's never been the law. Judge, I can't tell you how many cases that say just that.
I'm struggling a little bit with the plaintiff's burden of proof is preponderance. He doesn't have.
I think we lost you there, Judge.
We lost you, Judge.
He doesn't have to prove absolute. That'd be a much higher standard than preponderance. He simply has to convince the jury that it's more likely than not that he slipped in on the wet floor.
Judge,
that's the burden of proof, isn't it?
When we go to trial, the burden of proof now is what is the material issue of fact present. That is, in response, if you have other causes that are just as likely, which no one can claim otherwise, it's plaintiff's obligation to show the one they're claiming that he slipped is somehow more likely. The fact that you
Your Honor, can I
fall,
quote-
if that were true, Judge, anytime anybody fell, you would automatically have a jury question, because as the court claims, the burden of proof is somewhat different at trial. But the law is actually this: just because you fall doesn't give you any or doesn't allow you to get by summary disposition unless you can show more likely than not that your proposed reason for the fall is in fact what occurred. Now here, Judge, we all know anybody can fall, you can trip, you can slip, anything can happen. So what do we know here? Do we have any direct evidence that he slipped? The employee coming over later saying it appeared he slipped, that's not even admissible, let alone for these proceedings, Judge. All we have is his stepfather who says, I saw him fall and I was not looking at his feet, and I'm not going to answer any more questions along these lines. Judge, where is the issue? Where is that fact that we can present to anyone that says, okay, it's more likely that he slipped as opposed to any other possible cause? When the only eyewitness won't respond.
I think I've heard enough argument on this issue. Let's move to the next point.
Can I just quote from the Supreme Court on that issue, Your Honor, if I may, just one quote from the Supreme Court, from the Skinner case. On the other hand, if there's evidence which points to any one theory of causations indicating a logical sequence of cause and effect, then there is a judicial basis for such a determination. And this is a question of fact for the jury. There's a logical sequence of event. It doesn't, you don't have to prove more likely than not, but I'm finished.
Thank you.
So we'll move on to the next issue.
Next issue, please.
Judge, the next issue obviously is the open and obvious issue, and that is whether or not the conditions that an average user of an ordinary intelligence would be able to discover this condition on casual inspection, Judge. And as you can see where the water is located, Judge, in the diagram, that's the table that Mr. Zabrowski was sitting at. And when I asked him in his deposition, and I asked him actually at two separate points, the one is on page 21. Okay, when is it you first observed any water on the floor anywhere in the restaurant? Answer: after Tim fell, I noticed he was laying in water and there was water behind him. And I asked him later, so as to confirm, on page 24, okay, but after Tim fell, as you were standing there, you looked down and you could see the water, true? Answer: yes, because he was lying in it. He was wet. So we have an average user of ordinary intelligence, casual inspection. He looked down after Tim fell and the water was right there. And that's all that's necessary, Judge, for an open and obvious defense. And I don't know what more to say about that. Thank you.
Well, because you're wrong on it, Rick, and I'll just tell you why. The issue of what was seen afterwards, Your Honor, is not the test. And let me just say that I've been doing this for just about as long as you got, well, actually longer than Rick. And I've been focusing my practice on premises liability law, which not a lot of people can say because it's a tough area. However, the test of whether something is open and obvious is not whether you saw it afterwards. It's whether it was visible upon casual inspection prior to the fall. And we have testimony from Mr. Zabrowski that he never saw this. But more importantly, Your Honor, we have testimony from defendant's own employees that they never saw this. Amy, Elizabeth Maxwell testified, a question, were you able to see that, the water spots, as you were walking over, or did you not see it until later? Answer: I apparently didn't see it until later because I didn't see it at that point. I guess I didn't notice it too much because it wasn't a humongous puddle. Question: it wasn't that obvious? No, until I was looking. And Mr. Zabrowski never saw it beforehand. There's been several cases regarding freshly mopped floor. And virtually all those cases, none of which were cited by defendant, state that this is a question of fact for the jury. But let me point out something else, because the case just came down from the Supreme Court, and I'm sure the court is probably aware of it. Blackwell versus Franchi. It came down in August of this year. And we've seen over the years that this open and obvious doctrine set forth 30 years ago or more has really expanded to the point that now defendants are claiming almost immunity from any condition because it's open and obvious. The Supreme Court in the Blackwell case, they issued an order. This Court of Appeals, they affirmed the Court of Appeals, and in a rare decision, I thought it was fairly rare, issued an order. And what they said is, we're clarifying here that the focus is not necessarily on the plaintiff, it's on the defendant's duty and whether the duty was breached. And I attached that order to my motion because it's a significant case, and several cases have come down since then, focusing on the defendant's duty, not whether the plaintiff necessarily should have seen it, but what did the defendant do and did the defendant breach its duty? In this case, a freshly mopped floor, the evidence is that there were no signs. The evidence and the case law states that in these cases where there are no signs, this is a question of fact for the jury. None of the defendant's employees saw this, so why should my client be barred from presenting his case to a jury because his father noticed it after he fell? This is a case, Your Honor, where we've presented sufficient evidence to go to a jury on whether this is open and obvious. Let Mr. Gaudet make his arguments before the jury, but this is not a question of law to be decided by the court that reasonable minds couldn't differ, because reasonable minds did differ. In fact, plaintiff's own employees didn't see it until afterwards anyway.
Judge, if I may?
Yes.
Well, we're blending our issues here regarding the freshly mopped, and I'll get to that when we do the third aspect of this motion, Judge. But to say that he never saw it, that's true. He testified to that, Judge. So the man, Mr. Zabrowski, who's sitting right across from the chair that has the X in it, and the water is literally right next to the table, testified he never saw this water at all when he sat down or at any point thereafter for the 10 or so minutes, whatever it took him to eat before the two of them left. That's what he testified to. He never saw it.
Wouldn't that testimony suggest that it wasn't open and obvious?
No, what it would suggest is he didn't look or he's not telling the truth. But that is not particularly important, Judge, because what he testified to is after he stood up and after Timothy fell, he looked down and he could see the water. So the suggestion is that when he was sitting down and eating, he never looked at the floor and never saw the water. Because he testified once again.
But wait a minute. After he fell, and stepdad is looking down intently at his stepson who fell, and then sees that his stepson is wet and sees the water at that time. That sounds like a whole lot more than a casual inspection.
Well, Judge, that would be true because the word intently, as you used, was never used by Mr. Zabrowski and never used by me. I asked him very simply, okay, but after Tim fell, you were standing there, you looked down and you could see the water, true? Answer, yes. What more could there be to a casual observation? He didn't say, well, it was hard to see, but I could crouch down and then I could see it. Nothing like that. He just said, he looked and he saw it. What could be more casual? What could be more fitting with the law that currently exists other than that?
Well, the problem is defendants' employees didn't see it. I mean, there's case law in point, Your Honor. Whether he saw it afterwards is not the test. It's what was visible upon casual inspection after he fell. The Jaber versus Meyer case, which I cited, it's an unpublished Court of Appeals decision, came down in August of this year. The same set of facts. They said that the court denied the motion and the Court of Appeals upheld that denial. This is a question for the jury.
Judge, I believe that I'm sorry, Brian.
Well, no, I'm sorry. Go right.
Okay, Judge, I think that decision had to do with the plaintiff because the plaintiff testified that for whatever reason, he or she didn't see it before, but was able to see it after. And there are some reasons for that. Here, Judge, it's absolutely crystal clear Mr. Zabrowski stood up. He's following his stepson, de facto stepson. He sees him fall. He looks down and he sees the water. To me, that suggests nothing more than if someone would have looked, you would have saw the water.
Then why didn't your employees see it, Rick?
Well, but that's not the point. The point is one did see it. One said she saw a damp spot. She didn't testify to the extent of water that that your client testified to, but that's not the point. The point is that he testified, the one person who's standing there, the best position immediately after the fall, looked down, didn't say anything about having to do it intently or crouching or feeling around for it, nothing like that. He looked and he saw it. That suggests only one thing, Judge, that if Timothy would have looked, he'd have saw it too. That's all.
And the third issue?
The third issue, Judge, is the notice of the condition. And now we get to this issue regarding the mopping. Council mentioned several times in today that it was freshly mopped. That you'll never find that word, Judge, anywhere in the two deposition transcripts. As a matter of fact, I don't think there's any testimony as to when it occurred. Council used the term recently, and somebody thought it might have been mopped. But what they testified to, Judge, is there's two types of mopping that go on. One is a dry mop, where you have a dry mop and you're trying to mop wetness that's being tracked in from outdoors. And then a wet mop, where you're actually trying to clean certain floors or areas of the floor, depending on the conditions. There's no testimony as to which type of mopping occurred and when. There's testimony that it was recent, but what does that mean? That could mean hours. We don't have, well, think about this. If the mopping occurred, they would have walked right by it or through it, sat down and or watched somebody mop around them while they were eating, if that were the case. So what notice do we have of any condition under those circumstances, Judge? I think it's pure speculation to claim that it's freshly mopped when there's no testimony to that effect. Thank you.
I'm a little frustrated because Rick and Mr. Godot, your argument's misleading, because there is testimony. Defendant's employee, Ms. Maxwell, on page 27, testified. Question, did it look like it had just been mopped in that area? I could tell that it was mopped recently. This is on page 27. There were no streaks, but there wasn't any standing puddles either. So that I know it had been mopped recently. Question, what had been done recently? The mopping. The other employee also testified. Ms. Locke, question on page, this is on page 13 of her deposition. And why do you say the floor was wet? Answer, this is another employee, because one of my coworkers just mopped the floor. Question, just mopped the floor? Answer, yeah, it was wet. So when he says there's no evidence of when it had been mopped, I frankly find that disturbing, because there's clear evidence that it had just been recently mopped from his own employees.
Judge, I think went back, and I don't know if I could put my finger on it right now, but I'm virtually certain that when I asked her, or we re-asked her the questions, she was uncertain as to who mopped and when. And even if that were the case, Judge, if it was right then, they would have been sitting right there watching it. Sitting there watching it go on.
And I have the answer. This is on page, again, 15. Question to Amy Locke. And how do you know Stephanie just mopped the floor? Did you see her mopping? Answer, yes, I did. Question, in the dining room, yes. We have testimony from one employee seeing another employee mop the floor. Okay? When an employee creates an condition, there's no issue on notice. It's presumed. We know the floor had been recently mopped because Mr. Godot's two employees just testified to that effect. So there's clear questions of fact in this issue, and I appreciate Mr. Godot's passion, but passion should be saved for the jury. These are questions of fact, Your Honor.
Amy Locke is the one that testified that after the fall, she immediately went over to the area and she saw no water or wetness in the area. So she may well have testified as counsel indicates, but it's a red herring, Judge, because look at at any restaurant, you're mopping all the time. There's always mopping going on, dry, wet, or otherwise, particularly on a day where there's moisture outside that's being tracked in. But that doesn't change the fact that there's no direct evidence that this was somehow leftover mop water or anything to that effect. So we didn't have any notice of the condition.
All right. So, Mr. Kutinsky,
Yes, sir.
your brother counsel's last name is pronounced Giradat.
I call him Rick.
Well, that's a lot easier.
It's probably the hairdo, Judge. That kind of.
Well, we both have the same hairdo there.
All right. Thank you, gentlemen. I appreciate your arguments. Working backwards, Mr. Giradat, the testimony that you offer by one of the employees who went over to the area where this plaintiff fell and said she didn't see any wetness or dampness would certainly create a question of fact as to whether or not it was visible upon casual inspection. Hers would have been more than a casual inspection. She went over there while a guy was lying on or getting up from the floor, and she didn't see any water. I think whether it was open and obvious for casual inspection is a question of fact. I think whether there was notice of a condition, clearly there's a question of fact based on the testimony cited by Mr. Kutinsky, where we have an employee who testified it was mopped. I don't know how you could have any clearer testimony as to whether or not there was knowledge by the employer as to whether the floor was wet. If it was just mopped, it had to have been wet. And then back to the original question I posed, what is the plaintiff's burden? And I don't think the burden is any different at trial than it is at summary disposition, except at summary disposition, the plaintiff does have an obligation to come forward with some evidence, more than mere speculation, that it's more likely than not that he fell in wetness that was on the floor. And for that reason, I think there are questions of fact on all three issues that were raised. I am going to deny the motion. Mr. Kutinsky, you will prepare an order denying the motion, please.
Yes, I will. Thank you, Your Honor.
Thank you, gentlemen. Have a good day.
Thank you, Your Honor. Thank you.
You too. Thank you. Bye-bye.